Ladies and gentlemen, Taylor Wessing welcomes you to its third webinar dealing with trademarks and brands. In the next hour, my colleague Roland Mallinson and I, Olaf Gillett, will give you a short overview about registration strategies for brands in Europe, in particular the European Union. Our webinar continues the series of webinars that build on the issues and guidance given in our On Your Marks, Get Set Europe Brand Protection Guide, whose cover you can see on the right side of the slide. This guide covers everything from search and clearance, maintaining, exploiting, and policing your mark, to anti-counterfeiting, parallel imports, and advertising and marketing issues. It also covers the topic of today's webinar. If you are interested to receive a copy of the guide, please send us an email. You can also download it from our website. On your screen, you will find a Q&A box. Please feel free to send us your questions. We will either answer them at the end of the webinar if we have time, or we will send you a separate email. With this, I will now hand over to Roland, who will introduce you to the overlapping national, international, and EU systems and which to use when.
Thank you, Olaf. So, when the EU system was started in 1996, there was a political compromise that left the national trademark systems of each member state still operating. As a result, we have 27 systems operating within the EU in parallel, one for EU trademarks and 26 local or national systems. Now, overlaid on this is the Madrid international system. This means that in any one EU country you can secure registration rights through 4 routes. Firstly, a national registered trademark via the national IPO. Secondly, an EU trademark via the EU IPO. Thirdly, an international registration designating the relevant country via WIPO in Geneva. And fourthly, an international registration designating the EU trademark system, again via WIPO. I mentioned 26 local systems. The reason there are not 28 is that there is a regional system for Belgium, the Netherlands, and Luxembourg. Applications are filed at the Benelux IPO, and a single registration covers all 3 countries. It's like a little mini EU trademark system, with the difference that you can only cancel it before the court of the registrant's country, i.e. in either the Belgian, Dutch, or Luxembourg courts, wherever the owner is based. Each of the EU trademark national and international systems have their advantages and disadvantages, which the next 3 slides will consider. This table here shows some advantages and disadvantages of using the EU trademark system. I won't go through them all the points there, but I'll pick out a few. A key point is that the geographic coverage of an EU trademark can change over time. The upside is that EU trademarks originally covered 15 member states when it started in 1996, and now, without any extra charge, even at the time of expansion, they cover 28 countries. Now, assuming the UK leaves the EU trademarks are likely then to cover the 27 member states other than the UK. I will expand on Brexit a little later. Whilst one country is trying to leave the EU, there are a number of other countries at various stages of trying to join it. As a result, existing and future EU trademarks could potentially cover any of the following: Albania, Macedonia, Montenegro, Serbia, and even Turkey, and possibly future candidate countries of Bosnia and Herzegovina and Kosovo. Whether or not the EU system is the best to use depends on many factors. Key ones are likely to be the cost and how widely the mark will be used in the EU, and the nature of the mark itself. If we look at the first of these, the EU trademark system is the cheaper option if you want protection in more than 2 or 3 countries in the EU. It's also cheaper for enforcing against cross-border infringers, since you can obtain the usual court remedies on a pan-EU basis from just one court. In general, it has to be the court of the defendant's home country. Now, if we look at use, the EU trademark system is worth considering for those that want broad protection across the EU, even where they are not using the mark. For example, when suing under an EU trademark, a claimant does not have to have used their mark in the particular EU country where they are suing. Unlike for some national applications, for example the UK, they don't even have to have an intention to use the mark in that country. Perhaps most surprising for our US listeners if the registration is within the 5-year grace period from the registration date, the claimant doesn't even have to have used the mark anywhere at all before they can sue. It's only once the grace period ends that they need to have used it, and then generally they only have to use it in one EU country. So that means it can still be possible to sue in an EU country where the claimant hasn't used the mark at all and may never use it there at all. Now, the EU system is not so helpful for those trying to protect marks that are descriptive or non-distinctive in either one or more EU countries. Olaf will touch on this later, and likewise Olaf will be discussing the challenges and opportunities that arise from marks being different in different languages, so I won't address that here. So I now come on to the national trademark systems. You'll see that much of the advantages and disadvantages are the reciprocal of the previous slide. Key ones here to pick out are that you need to have local counsel for each country, so that adds to the cost for national filings, and the process runs in the local language, so specifications and possibly evidence have to be translated, which also can add to the costs. However, filing nationally can be useful in avoiding a dispute with the owner of a prior national right in a particular country that would otherwise block an EU trademark application. Such strategies are often developed after a clearance search identifies potential blockages. The other option is just to file the EU trademark application, wait till the opposition comes in, and then choose to convert the EU trademark if that blockage looks insurmountable. And you can make that conversion in some or all other EU countries. But this costs more and takes longer than if national applications have been filed to start with. There is one advantage that brand owners currently have, but which will be lost sometime between now and 2023. For now, in some countries, such as France or Italy, it's only possible to revoke or cancel a national registration with an action before their courts. Such actions are typically much more expensive than registry procedures, by as much as €30,000 in some cases, and they are also slower. But by 2023, this will change, since the new trademark directive requires all EU member states to have the option, by this date, of having revocation and cancellation actions dealt with by the IP offices. But now, though, it means that national rights in those countries, however invalid they may be, are less likely to be attacked by third parties, and so they can be more useful, even more useful than EU trademarks sometimes, as leverage in settlement and coexistence negotiations. So now we're looking at the Madrid international system, and I mentioned earlier about using national filings in the face of a potential blockage for an EU trademark. If protection is wanted in a lot of EU countries, it would then be better to use the Madrid system. That leads to a bundle of national rights that can then be centrally administered. It not only saves on local attorney fees, but it saves a small amount on the official filing fee and on future renewal fees, at the current Euro-Swiss franc exchange rate at least. Now, whilst the EU can be a designated territory in a Madrid filing, we generally advise against using an EU trademark as the base or home registration for an international registration. In time, this shortly won't be an option for British applicants anyway, since they won't have a real and effective place of business in the EU post-Brexit. The reason why we don't recommend this anyway is because EU trademarks are more susceptible to a successful challenge from a prior national right popping up somewhere in the EU. If that happens within the first 5 years of the international registration's life, the whole international registration becomes invalid, including all the country designations. Whilst they can be transformed into separate national rights, that's expensive and can be slow. So to reduce this risk, you can either do a thorough clearance search at the beginning in all the EU member states, which is expensive, or just use a national right as the home registration, which is what we normally recommend. So now we come on to registration strategies and language issues.
Thanks, Roland. As you can imagine, the overlapping trademark systems create a wealth of opportunities to protect your brand in Europe. The different systems become very important in light of the various languages that are spoken in Europe. For example, around 200 languages are spoken across the EU, and the EU alone has 28 member states and recognizes 24 official languages that use 3 different scripts. As a consequence, it is important to carefully select the appropriate system in order to see that your brand is properly protected. If you want to use the same fanciful brand all over Europe, an EU trademark might be the right choice. If your brand is descriptive for the goods and services it seeks protection for in one language of a member state of the EU, you should not seek protection as an EUTM, but as an international registration or national mark in order to avoid an objection. However, please bear in mind that even the descriptiveness of your brand in one language only does not necessarily mean that you will get the mark protected in all other countries of the EU. English is spoken and understood in the UK, Ireland, Malta, and Cyprus, and the Nordic countries, Sweden and Finland, and probably Denmark. German is spoken in Germany, Austria, and parts of Belgium, and French in France, Luxembourg, and Belgium. Some practical examples. The term savon, which is in the French language the word soap, could not be registered as an EU trademark, as the EU trademark covers the entire EU, including France. However, it could be registered in Bulgaria and Latvia, where the term would not be understood by the national consumers without an assumed knowledge of the French language, which they do not have in practice. Moreover, you should be aware of the different standards applied by the various intellectual property offices. Whereas the EU IPO in the past had the reputation of being rather relaxed in its standard for determining whether a mark is descriptive or whether it lacks distinctiveness, it became very strict in the past few years. The same holds true for the German and UK IPOs, whereas the Benelux IPO seems to examine applications less rigidly. The standard of examination is of special importance if you want to file a national application which shall serve as the basic application for an international registration. You definitely want to avoid an objection for your basic mark if another 50 country designations are depending on said application. The different standards clearly play a role in color or color combination applications. I will explore this topic later on when we talk about strategies for the protection of difficult marks. With so many languages spoken in Europe, not to mention differences in pronunciations or regional languages, it is important to verify that your brand has no negative meaning or connotation anywhere in Europe. This applies equally to fanciful, arbitrary, or invented terms. I found this example in the US, where the brand China Mist is used for tea. Well, mist in the English language doesn't have a negative meaning or connotation. Well, in Germany, the word Mist is the equivalent of rubbish for rubbish or trash, and you definitely don't want to call your tea China Rubbish or China Mist in German. So try to avoid these language issues. Having looked at the impact of languages and the difficulties to determine the right strategy, we will now deal with a rather easy subject, namely the drafting of a correct list of goods and services. Some introductory remarks. Specifications in the EU can be much broader than in other countries, in particular in comparison to the US. In addition, you do not have to show use for the specifications identified in a trademark application. And fees are calculated per class and not per specification. So what's the consequence? Your list of goods and services can and should be much broader and anticipate the potential expansion of your business activities. Now we come to the details. The EU IPO, as well as the national IPOs, are all bound by the 11th edition of the niche classification. Thus, all goods and services listed in the niche classification, including the class headings, should be accepted, in theory. This is unfortunately not the case. The class heading, personal and social services rendered by others to meet the needs of individuals of class 45, is not accepted by the EU IPO and by the vast majority of the national IPOs, except for Benelux. The Benelux IPO accepts this class heading. So using the class headings only is not recommended either, as the interpretation of what goods or services fall under a certain class heading varies from country to country. One interpretation of the use of class headings is clearly not acceptable any longer. Until the IP translator decision of the Court of Justice in the year 2012, the EU IPO was of the opinion that an applicant, by using all class headings of one class, was seeking protection for all goods or services of the specific class. Now, the use of class headings of the niche classification will be interpreted as including all goods or services clearly covered by the literal meaning of the indications or terms within the context of the class in which they are applied for, but not for all goods or services falling in the class. So, how do you draft a proper list of goods and services? You should use a good mix of general terms that are accepted and specific terms which are relevant for your business and that cover your current business activities. Always take into consideration that your business might expand into new areas and include the specification which might become relevant for your business in the near to mid-term future. On the website of the EU IPO, you will find pre-approved specifications and their translations that will help you to draft your list of goods and services. I will now hand over to Roland.
Thanks, Olaf. So, looking now at non-traditional marks in the EU, the EU trademark systems are largely in line with other parts of the world as regards what types of signs can and potentially be registered as a trademark. What tends to differ is how easily or not particular types can be registered. We have a new EU trademark regulation that hasn't sought to change the types of signs that can be registered, but the rules do now helpfully list the various types, and you can see the 11 listed here. Note that smells and textures, so that's the 12th and 13th, are not actually expressly included, but nor are they ruled out. In addition, there is a new concept of a certification mark, which is used to designate quality rather than origin, and you can see some examples of certification marks here that are likely to be registered under this system. When it comes to filling out the application form, a key recent change is that the sign no longer needs to be represented graphically on the register. So that is certainly under the new rules, the graphic requirement is gone. We don't know exactly what impact this change will have, but we do know that the representation can be submitted electronically, for example as a JPEG, an MP3 or an MP4 file. The new rules just require the representation to be clear and precise. In reality, those words are likely to be the subject of as much litigation as the old graphical representation test. Written descriptions are now optional for all types of marks, having been obligatory for one or two. And the EU IPO is operating under an unofficial what you see is what you get rule to identify what sign is being protected. Equally, the EU IPO is trying to be helpful by having published, albeit non-binding guidelines on how to represent the marks, but some already question if these apply the new law correctly. In our experience, most non-traditional marks will meet with some official objections, especially shapes and colour combinations. However, arguments and evidence of acquired distinctiveness can potentially overcome those. All these changes came into effect just 3 weeks ago, and they apply only to EU trademarks. There is also a new directive that hasn't yet been implemented to align our national laws with the EU trademark changes. So member states have until January 2019 to do that, which means for the moment there are more differences between the EU trademark system and the national systems than there will be in future. Applicants can take advantage of that or be tripped up by it. Typically, these non-traditional marks are enforced quite rarely. Most EU case law relating to such marks focuses on registrability and validity issues rather than enforcement. It means the scope of protection for these marks can be hard to gauge. But even so, our experience is that such marks, if applied for correctly, are not just trophy assets, but can actually provide helpful deterrent value.
So Roland just gave you an overview of non-traditional brands, including colors, shapes, and slogans. There are quite a few such marks registered as EUTMs and national marks but still a low number in comparison to traditional marks. It is also rare to see decided litigation cases relying on them. This makes the scope of the protection they offer hard to gauge. Most case law focuses on registrability issues only, but once such a registration has survived one challenge, it can have real value, deterring would-be infringers to secure early out-of-court settlements. In many cases, non-traditional trademark applications face objections because of an alleged lack of distinctiveness, or, in the case of slogans, because of their descriptiveness. Unfortunately, the case law can be very nuanced, and examination practice around the EU and even within the EU IPO can be inconsistent. This can mean it is sometimes worth having a go for the cost of an application. An EUTM application can be withdrawn after an initial objection without the reasons being open to the public, as the EU IPO does not publish this information in its database. Third parties can see then that an application was filed and withdrawn, and they may assume that it was objected, but that is not publicly stated. The same is not necessarily true for national applications in the EU. So this approach needs to be tailored on a country-by-country basis. After having received an objection, you may consider filing arguments. The likelihood of success depends very much upon the type of non-traditional mark. If the arguments fail, the only option to overcome an objection is to provide evidence that the mark has become distinctive over time. This can be an extensive and long drawn-out process. For national trademark applications, you will only have to prove the acquired distinctiveness for the specific country. For an EU trademark application, you will have to look at the type of non-traditional trademark. If a shape or position mark lacks the distinctiveness, the assessment applies to all EU member states. If a slogan lacks the distinctiveness or is descriptive, the objection only applies to the specific country or countries in which the language of the slogan is spoken. Thus, your burden to prove acquired distinctiveness depends upon the regional scope of the objection. It is still not finally settled whether you have to prove acquired distinctiveness in all EU member states or whether it is sufficient to do so in a substantial part of the EU. In any case, proving acquired distinctiveness is still difficult, and the outcome on an EU-wide level is uncertain. Next, I will explore a little bit about the various non-traditional trademarks. If you want to have the shape of a product, color patterns, and the like protected, do not restrict yourself to a 3D mark only. There are other options. You may consider filing a registered community design application simultaneously. A registered community design is a strong IP right against copies of your products. Bear in mind that you have only 12 months for filing a registered community design after you've made your product available to the public. So don't wait too long if you want to file a registered community design. As I said before, file simultaneously. If you want to have a slogan protected, you should consider a double filing strategy with an EU trademark application and national trademark applications in countries in which objections are likely. If the EU trademark is objected, your national application will mature into registration while you can argue against the objection of the EU trademark application. The double filing strategy, although costly, may not be advisable for slogans only. The reason for this is that the national IPO, the EU IPOs, and the courts are independent. Despite the harmonization of the trademark law in the EU, the national IPOs and the EU IPO come to different assessments of the protectability of non-traditional marks. In case there exist contradicting decisions on the protectability of a non-traditional mark, the courts still have to accept that the mark is protected under at least one trademark system. But, as you will have learned now, you can avoid conflicting decisions arising by withdrawing your application in time. Next, I will talk a bit about the geographic quirks of the EU trademark, which you can find on the map in front of you. It may be stating the obvious, but it's worth reminding everyone, more probably their business clients, that the EU trademark does not cover the whole of Europe. Sizable commercial areas are excluded, in particular Norway and Switzerland. Perhaps of some significance in the financial services sector, Guernsey, Andorra, Monaco and Liechtenstein are also not covered. Neither is the northern part of Cyprus. But Jersey, the Isle of Man and Gibraltar are covered. As Roland said earlier, various Balkan states might join the system one day. On the flip side, an EU trademark gives some extra coverage that may not be expected. In the Atlantic, it covers the Azores, the Canary Islands, and the Falkland Islands. In the Caribbean, it covers Guadeloupe and Martinique. In the Indian Ocean, it covers Réunion, and in the Baltic, it covers the Åland Island. They are located between Finland and Sweden, and I hope I pronounced it correctly. However, even though there is protection there, it is not clear if use in these territories amounts to use in the EU to defeat a revocation action. It would be dangerous to assume this. Of course, the question for the Falklands and Gibraltar and some other countries or above-mentioned territories may soon be academic, which brings us to Brexit, and that's a topic Roland will talk to you later during the webinar.
Thank you, Olaf. So just before we get on to Brexit, I wanted to cover an issue that is live, certainly with bigger portfolios. The generally accepted, this is the issue of overlapping and repeat filings you've got on this slide here. The generally accepted view is that use matters less in Europe than in the US, certainly for registrations that are still within their 5-year grace period. However, under the new rules, you now cannot rely on older registrations to the extent that the mark hasn't been used for 5 years. This applies to both opposition and infringement actions. It applies now to EU trademarks, but only to national rights once the new directive has been implemented. The consequence is that brand owners that are often opposing or suing third parties have a strong preference for relying on registered trademark rights that are less than 5 years old. And this is really a problem for businesses that are constantly developing and registering new brands. For example, those doing seasonal beers or short-lived TV shows and computer games. Others often have a rolling program of repeating their filings every 4 to 5 years to ensure that there is at least one prior right that they can rely on, which is still within its 5-year grace period. Such a strategy, disparagingly called evergreening, is not uncommon but often attracts criticism. Arguments have been run that these applications are filed in bad faith and so the registrations are invalid. So far, we've had nothing binding from the CJEU on the point yet, but we have had 2 EU IPO Board of Appeal decisions where the opponents relied on their more recent repeat filings only and specifically did not rely on their older registrations, and yet despite that, they were required to prove use. So this does mean that the strategy is not infallible for what are unused and maybe effectively defensive registrations. So now we come to Brexit. In the time available, I cannot begin to cover all the issues for trademarks that Brexit creates, but I summarise some of them here. The main concern at the moment is that we currently have a situation where the 2 parties to the negotiation, the UK government and the Commission, have not started any dialogue at all on this subject. Not even their respective expert bureaucrats in the UK IPO and the EU IPO have even been speaking to each other. And this is all when we've only got 18 months to go until the UK leaves the EU. Now, there's an alarmingly long list of issues that ought preferably to be discussed and agreed well before then. Clearly, this is a concern for all brand owners, wherever they're based, not just UK-based ones, And we, and certainly I, have been active in working with a number of organisations to try and get this changed in our lobbying efforts. But certainly I would encourage all brand owners to make as much noise on this subject as possible, in particular to the EU 27 member states and their local politicians and government representatives. Meanwhile, the following points are worth bearing in mind, even though we don't actually have any real certainty at all, and I list them here 1 to 9. It seems likely that the protection given now under an EU trademark will somehow survive Brexit in a form of a split-out national UK right. Whether this happens automatically and for no charge is not known, but both sides seem to think it would be desirable, not least to help the smaller and medium-sized enterprises. It means that there may be absolutely no need to file for new UK trademarks now that are duplicating your existing or new EU trademarks. However, it is clear that many people are doing this in an abundance of caution, and perhaps in relation to their key brands. It may also be to ensure that they have a live and subsisting right on day one of Brexit, which can be invoked, for example, in a domain name complaint or a notice and takedown request that has to happen on that day and can't wait for some weeks. Now, since it's unknown if the UK government will create a new UK right akin to the EU unregistered design right, there may also be merit in applying to register an EU registered design for designs that first published within the last 12 months. It's also best to avoid making EU seniority claims at present, and UK rights should generally not be allowed to lapse where possible. Another point, registrants of .eu domain names should be considered whether they will be able to continue owning that domain name and what alternatives they might want to use. Because UK holders of such domains won't possibly be permitted to use them without a base in the EU. A point to bear in mind is whether your current representatives have the options for being able to continue representing you before the EU IPO post-Brexit. And then finally, an important point to look at now, given reducing time, is to review all current coexistence and license agreements that refer to EU trademarks and have a definition of territory by reference simply to the EU. Those who are very prescient will have drafted that to talk about the EU as it is today or the EU as it is from time to time, but very few will have actually drafted accordingly. Right. Oh, excuse me. I managed to skip one slide without intending to. Yes, so now we've got really some key points that we wanted to pull together from what we've spoken about. Oh, I don't know how to get to this slide. I've lost it. I'll just run through those with you. We've got 10 key points. They should be coming up on the slide in a moment, but I'll walk you through them now anyway. First of all is register now. Don't wait until your expansion plans are more concrete. You don't need to use your mark or have proof of your intention to do so before protecting, and it can help provide you with a defence in the future. Secondly, check for prior rights, and not just those on the EU trademark register. If budgets allow, conduct proper clearance searches. This also allows you to better align your protection strategy to your needs, risks, and budgets. I think we've got it going again now. 3, if there appears to be a prior right blocking you, get local advice. With time and a careful strategy, solutions can often be found that enable your plans for the mark to proceed. Fourthly, make an informed choice about your protection. Don't assume that registering an EU trademark is necessarily right for you. There can be good reasons to seek other and parallel protection. For example, national trademarks, national or EU registered designs, or even just simply relying on unregistered rights. Fifthly, take into account industry-specific issues that arise in the EU and maybe not elsewhere. An example would be the requirement for a single pan-European brand for pharmaceuticals, or otherwise regulations to stop co-branding with tobacco products. There's also geographical indicators to be taken into account for things like regional wines and cheeses and beers. Finally, there's also sometimes a requirement to label non-EU packaged goods differently from those that are destined for the EU.
And sixthly, take a European view about the scope of goods and services for which you protect your brand. Do not automatically align it with the protection you have elsewhere, for example, as in the United States. Seventhly, use the centralized EU system for recording rights with customs. Put in place the infrastructure in-house or with outside counsel, to support local interceptions of infringing goods where you or counterfeits regularly trade. Eighthly, enforce your rights strategically through a careful choice of forum, whether in court or a registry. Suing in the right jurisdiction can secure you an injunction from a single court in all 28 member states, and secondary infringers can be included in that action, even if not based there. Ninthly, keep good evidence relating to the use and reputation of your brand on a country-by-country basis. Even if protection is on a pan-EU basis, enforcement can be nationally focused, and purely global or pan-EU evidence may be of known use. So you may have to start breaking down your figures country by country. Tenthly, when managing a brand portfolio, look at seniority and merger options to save money on future 10-yearly renewal costs.
Thank you, Olaf. So that actually brings us to the end of the webinar, and we have time to answer just a few of the questions that have come in. So thank you for sending those. So I'll take the first one. How do I know that a specific good is acceptable by an intellectual property office? I think, Olaf, that was covered by one of your slides. Would you want to talk about that?
Yes, thanks, Roland. Well, how do you know whether a good is accepted by a national IPO? I advise you to have a look at the EU IP website. There's a subchapter called TM Class, and on the website there's a harmonized. It gives you an overview of the so-called harmonized database. That's a database comprising 20-something IPOs which accept the same goods and services. So if you click the box, a harmonized database, and you look for a good or a service, and it will show up in the database, you will automatically know that it's accepted in all the participating IPOs. And the harmonized office database covers obviously the EU IPO, but also the German Patent and Trademark Office, the UK IPO, the Italian IPO, Polish, Latvia, Swedish, Spanish. So as I said, quite a few offices, more than 20. So that's my first advice. That's a very helpful tool. And if you want to look, look at the niche classification, WIPO has a very good tool on its website now. It's called MGS. That's the Madrid Goods and Services Manager, and it gives you the option to choose between the goods and services from the niche classification, and you can click them, collect them on the website, and then there's an icon which lets you check the acceptance by designated contracting parties, DCPs, and you can either check all the IPOs that participate in it, or just a few of them. And Austria is participating in it, Switzerland, China, Germany, the EU, Finland, the UK, but also the United States. So whatever you will find in that database should be acceptable in the countries listed under the Madrid Goods and Services Managers. So that will help, will help you if you are coming from a niche classification system, just looking at the Madrid Goods and Services Manager to see whether these goods and services are also protected in European countries. And I hope that answers your question.
Thanks, Olaf. I think you mentioned lots of links there. What I think we might do is send the questioner a link to some of those sites that you were talking about. I've got another one. You mentioned it's cheaper to file an EU trademark via the Madrid system. How much money does it save? I think it depends on the number of classes, and also whether or not you've actually got a pre-existing international registration and you're merely extending it to the EU. In that situation, I think you'd save about 80 or 90 euros, and you save about the same on renewal costs, which, if you've got a large portfolio, is certainly worth considering. But if actually you're filing a brand new international, then you're probably not saving an awful lot. I've got another one here. Could you please clarify on the new rule as of 10/1/2017? So I think that's 1st of October, isn't it, 2017? Did I understand correctly that a claimant can't simply rely on an EU trademark registration in an infringement action, even if it's less than 5 years old in an infringement action, and that the claimant must prove use of the mark? No, that's not right. So if the EUTM is less than 5 years old, they don't need to prove use of the mark. I was referring to two Board of Appeal cases, which was in an opposition, and in that situation, the Board of Appeal and I think the first instance opposition division had said that because the opponent was relying on a right that was less than 5 years old, which was essentially a repeat filing, and because the opponent also had a much earlier and older right, which was more than 5 years old, and there was no apparent evidence of use of either of the marks, the mark over any period of time, they were put to proof as if they had relied on the older registration. Now, I have to say, it's slightly questionable where that rule necessarily derives, but that's certainly been the position in a Board of Appeal, two Board of Appeal decisions at the EU IPO. But certainly, in terms of an infringement scenario, and particularly if you've only got one trademark and you don't seem to have a history of obvious repeat filings, then there is no need to prove use for a registration that's less than 5 years old when you come to sue. So I hope that answers that one. Now, one more.
If a registrant owns an EUTM for a service mark actually used as a certification mark, but be filed before the introduction, do you recommend refiling now as a certification mark? If so, why? What benefits? So clearly, yes, we recommend to refile it as a certification mark. The concept of a certification mark, whether you've used it before as a certification mark or not, the concept was unknown on an EU level. So it did not have protection as a certification mark. The concept did not exist. So if you want to have protection as a certification mark now, you have to refile it. Whatever you had before was a service mark, but not a certification mark. I hope that answers the question.
Now, here we go. Does the EU IPO and the national PTOs do an extensive searching when a name is filed? Well, it depends country by country. Certainly in the UK, what will happen is that the UK IPO will do a search of prior rights, but it will only be reporting to those who have got a prior UK right. It used to originally report if you had a prior EU right, but now it's just reporting if you've got a prior UK right, and it will tell you about a subsequent, subsequent filing. And the EU will alert you to other prior rights, but it won't obviously block it. Olaf, and your experience on other offices?
Yes, the EU will only inform you about other EU trademarks, but not national ones anymore.
Yeah. Would the UK IPO, sorry, final, it looks like one more question here. Would the UK IPO provide a transitional period to allow EU trademark holders the opportunity to register the UK trademark? Well, there's a lovely thought. We are trying to, the talk of transitional periods, we have no idea whether we're actually going to have them. Of course, the UK government is currently talking about that, but the EU 27 member states have not indicated whether that's going to be acceptable at all. And rightly, the question actually is unilateral to some extent in any event, and therefore purely a UK government point. I think what will happen probably is that the existing EU trademarks will actually automatically flip across and be split out into the UK. I'm using the word novation for this. You can't use the word transformation or conversion, by the way, because they're obviously arising in other scenarios. And so, in fact, I doubt there will be a process. I can't guarantee, of course. I doubt there will be a process that will involve opting in or some sort of human process of reapplying. We're not getting those noises currently from the UK IPO, although they are trying their best to not reveal any of their thinking at the moment. But certainly they are keen to ensure that no one loses their rights inadvertently. So they will certainly do their best to make sure that those who have filed for an EU trademark covering 28 member states, which includes the UK, and paid for that, they will continue to have that right, certainly until it's next due for renewal, and then after that point they'll have to pay the renewal fee in the UK. So I hope that answers that question. I think we should probably, I'm anxious that some of the other questions I can see are so specific that it might be best done by email, to be honest. So I suggest that we're probably going to draw a line there, unless you have any other thoughts on that, Olaf. And we would then just bring ourselves to say that this has been recorded, this webinar, and so for those of your colleagues who've not been able to listen, you could send them a link and it'll come out on our website. We can send that to you. We'll also send you a link to the ebook, which is obviously what you can see on the screen there. In fact, in the resources window on this webinar, you can actually link through to our website and find the ebook. As Olaf mentioned at the beginning, you're very welcome to ask for a hard copy of the book, and we'll send it out to you. So then it just remains for me to say on behalf of both myself and Olaf, thank you very much for listening to us. We hope you found this useful. We'd very much welcome feedback and also suggestions on other topics that we could cover in our ongoing trademark webinar series. So thank you and goodbye.
Goodbye.